taking hairs already. So. Good afternoon. Welcome to our webinar today on required client and court disclosures for cases where you're bifurcating your Chapter 7 fees and also potentially using a third party for financing or payment management. My name is Dan Garrison. I am one of the founders and managing directors of Fresh Start Funding and also principal of Protego Law, which provides defense to attorneys who bifurcate Chapter 7 cases across the country.
Hi, and I'm Matt Hartley. I'm also a founder of Fresh Start Funding and a member of Protego Law.
So we're going to be talking today about two fairly dense subjects. So we're going to talk about required client and court disclosures. We're using Zoom. For those of you who are familiar with it, there is a Q&A function. We are going to be taking questions at the end of this webinar. So if you want to go ahead and type those in at any point in time that the question pops into your head, we'll try and handle those at the end. We're going to go probably about 45 minutes. We're going to try and do it within that time, but we're going to have to move pretty quickly because we've got a lot of ground to cover today. So we'll start out with some basic background on bifurcation and on the sort of practical reasons why folks work with third parties for financing and payment management when they accept post-petition fees. Yeah. And if you're interested in a deeper dive on those topics, we have some other webinars on our website on basics of bifurcation. We've got deeper dives into the case law supporting it, including some of the more recent developments in the space. We're not going to cover those today because we've got so much of the nuts and bolts to cover. Yep. So given how much time we have and how much we need to cover, Matt, do you want to jump in and kind of give everybody a foundation in bifurcation?
Yeah, so just a very simple version of bifurcation. What it's all about is allowing debtors to get their cases filed right away and make payments post-petition. And what the case law has laid out over a process of at least 25 years and really dialed in since 2012 is that you can do this, but there's a right way and a wrong way to do it. And the right way basically is just that you need to have two different fee agreements with your client, one that's signed pre-petition for the pre-petition work that you perform, and then a second agreement signed post-petition, which is for the work you provide post-petition. And then that second post-petition agreement, since it is signed post-petition, you can collect fees under it. You're not going to violate the automatic stay or the discharge injunction. But again, it's critical to have the two agreements. But as we mentioned, the case law has been great on this, especially since 2012. The courts have all aligned themselves with the correct practices and how to do this. And we have lots and lots of information on this, as Dan said, and some other webinars that you're welcome to view.
Yeah, we have a lot of other resources on the website too. So we have a number of articles we've published in the ABI journal. We also have copies of disclosures and things that we're going to talk about today so that you can take a deeper dive, with the documents themselves. So the question comes up, just supposing I can bifurcate or I choose to bifurcate, what are the practical considerations?
Yeah, well, the first obvious one is if you're not getting paid by your client up front, and you're going to allow them to make payments to you for a year, you're going to have a cash flow challenge. Because obviously, traditionally, when you get paid up front, you have your money, you perform the work, you don't have to worry about the money coming in. But if you file right away and you're waiting 12 months, it does create a cash flow problem. And that's really one of the several services that we provide to the attorneys, is that we provide financing so that attorneys can, in fact, get their money up front. The other important piece of this is the payment management, because when these clients all start making payments for 12 months, there starts to be lots and lots of payments to collect. Yeah. And we handle all of that as well for attorneys. And as you can imagine, we make the example sometimes where if you file 10 cases a month that you're collecting payments on, and say you're collecting weekly payments, by the end of the year, you have 120 clients, each making 4 payments or more a month, and you end up with over 500 payments a month that you're managing. And law firms, even big law firms, have done this in-house. They much prefer to have a company like us with our economies of scale, our technology, our people. We can take over all that headache and make sure it's all handled in the best way. And then the other service that we do provide is credit reporting. So when clients start working with you and with us, then we can report their payments to the credit bureaus and help them rebuild the credit, which is really powerful in those initial consultations with your clients, getting them on board. And it's just really good for the debtors to have a shot at rebuilding their credit right away.
We're going to talk about a couple of other concepts too that it helps to have a little bit of background in diving into the disclosures. And one of them has to do with the structure of the financing. And so you'll hear us talk about factoring versus secured or recourse financing. that's an important distinction. Fresh Start Funding actually provides financing to the attorney for cash flow purposes and takes a lien against the fee receivables, which is something that's accepted under the model rules, and state by state, there are ethics opinions out there noting that you absolutely can get a line of credit from a bank or some sort of third-party financer, and it doesn't amount to fee sharing. There's another kind of structure out there called factoring, where you actually sell your receivable to a third party and they become the owner of at least the financial portion of your relationship with your client. And that has been frowned upon in a number of states. In fact, there are some states that have ethics opinions that say flat out that that is fee sharing in violation of Rule 5.4 of the Rules of Professional Conduct. So when we get into the disclosures, that's a distinction that we'll bring up again that it helps to have a little bit of a foundation in.
Yeah, for sure. Okay, well, good. Well, I guess we can talk. So the main two areas that we're going to be talking about today are the disclosures you have to make to your client and how you get their informed consent. And then the second part are the disclosures to the court. Both are super important, but the attorneys around the country that have gotten in trouble almost always fail to do one or both of those in a correct manner.
Yeah, I would say of the 3 or 4 ways in which attorneys have questions asked or get into some hot water with trustees or judges, disclosure issues, getting informed consent from the client and giving appropriate disclosures to the court are easily the top 2 pitfalls that exist in bifurcating Chapter 7 cases and in using third parties like Fresh Start Funding to provide financing and payment management services. So let's start out talking about client disclosures first. And client disclosure issues really have their foundation in sections 526 and 528 of the Bankruptcy Code, and then just the general provisions of the Model Rules of Professional Conduct that deal with getting informed consent and acting in your client's best interest. So let's start out by taking a look at section 526, which I hazard a guess is a section that not a lot of you are very familiar with. So section 526 is a very dense provision. We're going to focus on subsections A and C. Subsection A talks about the fact that a debt relief agency, which includes any attorney who's providing bankruptcy-related services, that they shall not, and then in subparagraph 3, misrepresent the services that said agency will provide or the benefits and risks that may result if such person becomes a debtor in a case under this title. And then in addition to that, there is another subsection that talks about the fact that any contract that's entered into between a debt relief agency and an assisted person, which is a debtor, that does not comply with section 528 shall be void. So 526 is sort of the initial foundation for disclosures to clients. You can't misrepresent and you have to comply with 528. So let's take a look at 528 and see what it says. So section 528A says that a debt relief agency shall, not later than 5 business days after the first date on which the agency provides assistance, but prior to such assisted person's petition being filed, shall execute a written contract with the assisted person, and I'll just use debtor from this point on, that explains, and I want to emphasize, clearly and conspicuously, which turns out to be important, A, the services that such agency will provide, and B, the fees or charges for such services and the terms of payment. Now, I will tell you, a lot gets made of this provision in the context of bifurcation, talking about all the different things that need to be disclosed to a client, a debtor. But in fact, when you look at 528, it's actually quite simple. You have to clearly and conspicuously disclose the services that you'll provide and the fees and charges for such services and the terms of payment. Now, this will become a pattern in our presentation today. We're going to highlight for you what the statutes or the rules actually require. And then we're going to talk about sort of best practices, a recommended approach to this that in our view greatly exceeds the minimum standard of the code and the rules. So let's talk a little bit about those best practices, given the fact that this bar that's set by 528 is relatively low. So Matt, you want to kind of walk through the substantive things that we recommend?
Yeah, so the first thing is just describing the nature of the bifurcation. You need to make sure your client understands exactly how you're doing your services, which obviously is going to involve 2 different agreements. And so your first agreement, your pre-petition agreement, is going to describe very specifically the services you're providing, which in most cases is just to file a skeleton or emergency case. So just the minimum documents. It also has to clearly disclose to your client what their options are after that's complete. And in most cases, it's the options of either hiring you to finish the case, which would be entering into the second agreement. It'd be going forward pro bono,
Pro se.
pro se, or going pro bono, pro se, or it would be hiring a different law firm. And you also need to provide some descriptions about, the pros and cons of some of those different options. But you have to make it very clear, for another reason on unbundling issues, that you are ready, able, and willing, though, to proceed with your client for all services necessary to do the Chapter 7. They just have to sign that second agreement with you. Then I guess the next thing is you have to outline the payment terms. So as it says in the code, you have to be very clear in your payment terms. So you need to make sure that they fully understand the total amount of the fee, how much they're going to be paying, the frequency of payments, so they can be paying monthly or weekly, and of course the term. Are you allowing them to pay for 12 months, which is what we do, or you're giving them 3 months to pay, or what it may be.
There is actually a practical practice pointer here that helps with getting informed consent, presenting the options, and laying out the specifics of the payment agreement. We actually recommend that attorneys have a single sheet of paper that lays out, if there is a prepaid option that you're offering folks, and then a pay over time option, and that pay over time option illustrates really clearly what the differences may be in the fee and what the specific payment terms are that would apply if they choose the pay over time or the bifurcated option here.
Yeah, and that's actually a super interesting area, because there's nothing in the code that says you have to have 2 options or anything else, but the cases have really said that. The cases have said they want to make sure the client understands the 2 options that they have. And so best practice, again, is to do that.
No, and most attorneys, and rightly so, if they have a client walk into their office who can afford to pay up front, will be happy to take the fee all at once and not have to deal with payments, not potentially have to pay a fee to a third party like Fresh Start Funding to extend financing and so forth. And so if you do have those 2 options, one of the easiest ways to demonstrate that you've gotten informed consent and that the client is aware of their options is that you present both those options to the client and let them choose the one that's best for them.
Yeah, and the other really important piece in all this too is that with most attorneys that bifurcate, they charge two different fees too. So they'll charge, if a client pays up front, it's one fee. If a client wants to pay over time, it's a higher fee. And so that also has to be clearly disclosed if you have those 2 options, because your client does need to understand they have the option of paying less and paying up front, or paying more and paying over time. And because that's one thing where the court's going to want to make sure that it's in the client's best interest, and nobody knows the client's best interest better than the client. So if you're being very clear with your client on their 2 options and they are clearly choosing which one they want, there's really no question, or should be no question, as to whether or not it was in their best interests.
Yeah, and one quick note, it's not a topic we're going to dive into in depth in this webinar. We do in some of our other webinars, and that's reasonability of fees. So one of the other pitfalls is that the fee for a bifurcated option needs to be reasonable under Section 329. A lot of attention is given to what's characterized as an upcharge between the prepaid fee and the pay over time fee. But what the case law across the country very clearly says is that you need to look at the fee that's actually charged in terms of a reasonable market hourly rate and a reasonable amount of time. And that sets what's called the lodestar, or the basic assessment of reasonability. And so having those options, though, clearly spelled out for the client makes it much more apparent to trustees in the court that the client understood the choice they were making, made it voluntarily, and took into consideration their own best interest.
Yep. The next thing you want to be clear on, we talked a little bit on, is just making sure you are, in fact, being clear about the services you're going to provide, so that it's not a question of violating any unbundling rules that may apply in your location. The Hazlitt decision out of Utah, which probably most of you are familiar with, did talk about this and analyze whether or not bifurcation is like unbundling. If you haven't read Hazlitt, you need to read it. But it does describe how bifurcation is different. And it's really that ready, able, and willing thing that I mentioned earlier. That's the piece that makes a difference. Because in unbundling, you're only ready, able, and willing to provide a limited amount of services. And that's where the problem is. In bifurcation, you're ready, able, and willing to provide all the services that are necessary. You're just providing them under 2 different agreements.
Yeah, and Judge Anderson in the Hazlitt decision really kind of nailed this in terms of the policy basis for things. So unbundling really is just kind of a colloquial term for a limited scope representation, or the idea that you're going to provide less than the full range of services that's typically required to handle a Chapter 7 engagement. And Judge Anderson pointed out that the rationale for that rule is to make sure that people have capable representation throughout the entire Chapter 7 process. But then he very insightfully noted that bifurcation is a process that allows people access to counsel and makes it easier for them to be able to pay for an attorney to represent them through the entire process. So one of the things we talk about is that, when you're disclosing things to the client, we also recommend that you have them acknowledge that they're choosing the pay over time or bifurcated option specifically so they can hire you for the entire case. And it's not with the intention of just consuming the limited services that you're going to provide under the pre-petition agreement. But it's basically a structure that they're taking advantage of in order to facilitate representation throughout the process.
Yeah. And so then really the last part of client disclosures that we need to talk about is when you work with a finance company like us, there are some disclosures you need to make to your client as well. And these really fall under the general ethical rules or rules of professional conduct that we will operate underneath. So those requirements are, one is you have to should identify who it is. So you'd want to mention for us Fresh Start Funding and state what we do, the services we provide. So we provide the financing, we provide the payment management, we provide the credit reporting, amongst other things we provide. And then just be very clear then about the costs that Fresh Start Funding receives for the expense that's paid to us, the fee. Make sure that's very clear in there as well. And also, this is very important too, make sure that you're disclosing the fact you're going to be doing some information sharing with the third party lender. And again, you wouldn't never, and we certainly would never require a complete disclosure of a file or any attorney-client privileged information. But there is certain information we need just to be able to process payments and to report their payment histories to the credit bureaus. So there is a limited amount of information that is shared with us.
Yeah, and really, as Matt said, this has to do more with the rules of professional conduct than it does anything in the bankruptcy code. What we're trying to do here is strike that balance with the client's informed consent, that you are honoring the confidence that you have with the client and only sharing limited information, and that you're maintaining your independence and your own objective judgment to act in the client's best interest. So we have recommended disclosures that would go into an engagement agreement that explain that in easy to understand terms for debtors.
Yeah, so actually it looks like maybe we have some questions here about the disclosures. Joni, if we can move that over on the screen so we can see the full question.
So yeah, Jason asked, should the fee structure for the post-petition agreement be addressed in the pre-petition agreement? And the answer is yes, absolutely. So you'll see if you look in our recommended forms that we have on our website, we'll have a link for you to be able to access those as sort of a reward for sitting through our webinar today. The pre-petition agreement lays out the entire case structure and says, here are the options that you have after we file your case. One of which is that you'll sign a post-petition agreement that will have a pay over time kind of option built into it. And typically we recommend that the attorneys literally give a copy of that post-petition agreement to the debtor at the time that they sign the pre-petition agreement, so that it's absolutely clear what the structure will be if the debtor chooses to go ahead and have you handle the entire case, which I can tell you 99.9% of debtors actually do. There's very little fall off in people signing pre-petition agreements and not executing the second one. And then do you have to file a skeleton petition to offer a post-petition contract? And the answer is no, you don't. Steve asked that question, and bifurcation really just has to do with splitting the engagement into two pieces. Now, it turns out that what's most advantageous for debtors and most attractive to them is offering something like a zero down option where they don't have to pay anything for your pre-petition services, meaning you're waiving those fees. Not that you're pushing it all to post-petition, but that you're waiving them. And so economically, it makes the most sense for attorneys to try and put as much of the work as they can into the post-petition environment. So typically folks will file schedules and statements after they file the case and do that pursuant to the post-petition agreement. Now, one common misunderstanding about that practice is that you don't do your diligence, that you file it as though it's an emergency case, and that's not at all what we recommend. We recommend that you use a thorough consultation and a good intake questionnaire and asking for documents to make sure that they're eligible, make sure it's in their best interest, and try and uncover any landmines that you can in the case before it's filed, but then simply actually do the exercise of preparing schedules and statements and reviewing them with the client and so forth post-petition.
Yeah, so actually we have a comment here. I guess not sure when it came in, but it's something we did talk about a little bit. But Jeff has raised the issue about unbundling, and again, that's unbundling is not the same as bifurcating. And we often talk about how really a good description of it would be like in your first year real property law case, you have the unbundling, the bundle of sticks that represent all the different pieces of an interest in real estate. So what the courts are, what unbundling is trying to get at is what's usually called limited scope representation, which is unbundling. And that is just when, and I guess the concern is that you have an unscrupulous attorney, and I know there's none out there, but an unscrupulous attorney will say, hey, I can fire Chapter 7 for $500 or whatever, and they're only going to do just the most minimal services and not enough services to actually complete a Chapter 7. That would violate unbundling. That's a limited scope. Outside of bankruptcy, you can actually do that in most areas, but in bankruptcy, you usually cannot, and that's a problem. But bifurcating is not just giving that portion of the sticks. You have all the sticks. You just have them in two hands. And so you have the pre-petition work and you have the post-petition work. And again, Hazlitt deals with this. Again, I would recommend, Jeff, you take a look at that. We'd be happy to talk about it offline as well in more detail. But bifurcation, since you're ready, able, and willing to provide all the services, it's not unbundling.
Yeah, and we've actually got some good briefing on this because the question has come up in a few courts across the country. And as some of you may be aware, part of our services are that we provide a defense guarantee and an indemnity for the attorneys that work with us. And so I actually do have occasion pretty regularly to go out and educate judges and litigate these issues sometimes. And the question of unbundling has come up, and we've got some great resources that kind of walk through this from a rule and a case perspective. Yeah.
And another interesting piece that I think, though, is that, not a lot, but some states have real specific rules about unbundling. Yeah. Minnesota, Missouri, I mean, just name a couple. But what's interesting to me is that those rules on bundling are no different than what the code requires anyway. Yeah. I mean, you're required to, once you start a case, you're required to complete a case until the court lets you out. Yeah. So you can't even agree that I'm only going to do this much in your case and just say then I'm out. You're committed to completing a case until a judge agrees that you can be out of it.
No, and I think it's a fair point too to note that in most jurisdictions, if you file a bankruptcy for a debtor, you are counsel of record until and unless the court lets you out. And some districts have very clear local rules that say only in the most extraordinary circumstances are we going to let you out of the case. And so if you do have that 0.1% that I referred to earlier of debtors that don't come back in and sign the post-petition agreement, you can ask the court to withdraw, but if the court doesn't let you, then you're going to have to see the case through. Now, as a practical matter, if the debtor doesn't show up and sign the post-petition engagement, they're probably also not showing up to sign their schedules and statements. They're probably not showing up to their 341, and the case is likely to get dismissed just administratively anyway. But we have a lot of experience both directly and vicariously in this, and it is almost without exception that debtors show back up and sign the post-petition engagement agreement because that's how they're able to pay their fees over time. Yep. One last question, and then we need to move on because we really intended to do Q&A at the end. Jack asks, which account are the funds deposited in, trust or operating? And the answer to that is a product of your own state rules of professional conduct, and the practice varies somewhat. Most states do allow you to put a earned on receipt retainer if you are actually committing to provide all the services and carving up your availability to facilitate that. They allow you to put it into your operating account, but there are exceptions and you need to look at your own local rules for that.
But a couple of things on that point though too. So if you're using us and you're getting money from us, that's actually not money from your client. Yeah. So that money has nothing to do with your trust account. You're just
we'll talk about that. Yeah, when we talk about the fee sharing issue, because there is a kind of a conflation of two different concepts there that we want to talk about.
Yeah, and then even payments received post-petition are typically the work's been performed anyway, and so it doesn't have to go in a trust account because you're being paid for work already performed. So and we can go into a lot of detail on that, which we won't today. We'll talk about a little bit more, but we're happy to talk offline about that.
Sure. Okay, so this is the point at which we want to transition to talking about court disclosures. So we've got a roadmap laid out there through the case law and best practices that we recommend and forms and so forth about how you should deal with your client. Now we want to talk about how you deal with the court. And fundamentally, it all starts with Section 329 of the Bankruptcy Code. And so, Joni, if we could pull that up. So Section 329A provides that any attorney representing a debtor in a case under the Bankruptcy Code, whether or not such attorney applies for compensation under this title shall file with the court a statement, and this is the key, of the compensation paid or agreed to be paid for services rendered or to be rendered, and the source of such compensation. So again, a lot is made of disclosure, and we're going to make a lot of pretty thorough recommendations to you about what you should be including in your disclosures, but it's important to note as a baseline proposition that what Section 329 requires is actually quite simple: a statement of the compensation paid or agreed to be paid and the source of that compensation, period. So now let's kind of walk from 329 into the rule that implements it, which is Rule 2016B. So let's switch to that. So Rule 2016B provides that every attorney for a debtor, whether or not the attorney applies for compensation, and this is just a rule that applies both to estate professionals, which includes counsel in 13s and counsel in 11s and so forth, but also to attorneys who represent Chapter 7 debtors who are not estate professionals and don't get compensated administratively from the bankruptcy estate. But every attorney shall file and transmit to the United States trustee within 14 days after the order for relief, or at another time as the court may direct, the statement required by Section 329 of the Code, including whether the attorney has shared or agreed to share the compensation with any other entity. And then it goes on to talk a bit more about compensation sharing. But what I want to highlight here is first the underlying portion that notes that this can be filed up to 14 days after the order for relief. Now, a lot of software packages will just by default include a Rule 2016B or a Form B2030 disclosure with your petition. And in a bifurcated case, you haven't entered into the post-petition engagement agreement or post-petition services agreement until after the case is filed. And so the practice is generally that you file your Rule 2016B after the second agreement's been filed, where the remainder of the compensation, comes into effect and you can describe the terms of it and so forth. Mm-hmm. And then substantively, all Rule 2016B requires is the statement required by Section 329 of the Code. So again, very simple. So the way that Section 329 and Rule 2016B get implemented, where the rubber hits the road essentially, is through a form called Form B2030. And B2030 is what's called a director's form. And Joni, why don't we go ahead and click off the slide here for a second. So there's an interesting context here that not a lot of people understand. So there are official forms in bankruptcy that are prescribed by the Judicial Conference of the United States. The petition's a good example of that. You really can't futz around with that. You have to use it in the form that's provided by the Judicial Conference. But then the enabling statutes authorize the director of the Judicial Conference to issue what are called director's forms, and those forms are issued for the convenience of attorneys to comply with the rules. Their forms are not rigid. They don't have to be used exactly as they're issued. And what the enabling statutes say is that you can modify them as needed to fulfill your obligations under the code. B2030 is a disclosure that is a director's form. And so what we're going to talk about today is we're going to talk about the provisions that are already in the templated form, talk about how they may need to be adapted in order to kind of get a best practices kind of approach to dealing with bifurcation and third-party financing and payment management. And a lot of the territory we're going to cover is actually covered really thoroughly in an article that we published in the ABI Journal in July of 2019 that dealt specifically with disclosure issues. So if you want a little bit deeper dive into this, that article is a good resource. And then, as we've said before, we'll have forms on the website as well.
And one thing we should add, because it comes up sometimes, is some of the local jurisdictions also have their own fee disclosure form. And we've seen them from lots of different states, but at the end of the day, they are all almost identical to the federal form, and the local rules aren't any different or don't require any additional disclosures or don't impose any limitations on modifications to the form. They just have their local form for whatever reason.
And, I actually spent 25 years as a Chapter 11 debtors attorney. And in Chapter 11 practice, I can tell you it's rare, if ever, that attorneys use Form B2030 or any local variation on it. When they want to comply with Rule 2016B, they typically file a declaration that's just custom to the case. And so these forms, they take on a certain kind of cachet, if you will, in Chapter 7 practice, but they are actually very flexible by definition.
Yeah.
So, okay, so in summary here, we have Section 329 imposing the obligation to disclose. We have Rule 2016B sort of implementing that and requiring the disclosure to be filed. And then Form B2030 or its local variant is where the rubber hits the road in terms of how you accomplish that disclosure. Now, there is one other interesting point I want to make here, and that has to do with Rule 2017. And Rule 2017 governs who has authority to look into or question transactions between an attorney and a debtor. And it'll become apparent here in a second why this is relevant. So 2017A provides that on motion by any party in interest or on the court's own initiative, the court may determine whether any payment to an attorney is excessive. And in contrast, B says that on motion by the debtor, the United States trustee, or on the court's own initiative, the court may determine whether post-petition payment is excessive. Now, we bring this up in the context of disclosure because one of the parties that often ends up asking questions about a bifurcated structure is your panel trustee, your Chapter 7 trustee at a Section 341 meeting. And I don't think there's anything wrong with trustees asking to understand the structure of the engagement. But what Rule 2017 illustrates pretty clearly is that the only parties that have standing to challenge the terms of a post-petition engagement agreement and any payments or compensation that's going to be paid pursuant to it are the debtor, the United States trustee, or the court acting sua sponte in a case. So just a passing note there to kind of give you some context. So let's talk about Form B2030 and what it contains just as a stock form. And essentially what B2030 contains is a series of questions and check the box alternatives that are designed to provide a framework for you to, and actually Joni, let's not get there quite yet. Let's go back to the screen. Sorry about that. So we have a series of check boxes and questions that are designed to give a basic framework for disclosing compensation, but they also have a question about fee sharing. And so I want to talk about that just a little bit. Yeah. It's not fee sharing per se. What it asks is if you're sharing compensation with any other entity. And that is actually a question that implements not Section 329 so much as Section 504 of the Bankruptcy Code. And Section 504 says that an estate professional, a party that's going to be seeking compensation from the bankruptcy estate, may not share compensation with any other person except for a regularly associated attorney within their own firm. Now, the rules of professional conduct allow you to share fees with other parties in most circumstances, as long as the client knows about it and consents. And so the question often is raised in the context of bifurcation when you use a third-party financing company, are you sharing compensation? So we talked about fee sharing a bit and factoring versus secured financing. Where you're factoring, there is a legitimate question about whether you're fee sharing in violation of the model rules. But the question on Form B2030 actually has nothing to do with garden variety fee sharing, which is prohibited in virtually every state, except for the District of Columbia. The question on B2030 really has to do with attorneys not being able to make an end run around Section 327 of the code, which requires all professionals to file an application seeking approval for their employment. And by sharing compensation with people outside your firm, you're potentially subverting that policing requirement that the court has to make sure that all professionals are disinterested and that the terms of their compensation are approved in advance. But that doesn't actually apply to Chapter 7 attorneys because Section 504 is restricted to professionals that are seeking compensation from the estate under Section 503. So we'll touch on that a little bit more as we go through B2030, but I wanted to lay that foundation. So let's talk about recommended disclosures here. And I want to highlight again the fact that 329's requirements are super simple. You have to list the compensation that's agreed, that's been paid or agreed to be paid, and the source of the compensation. And those are the only two requirements called out in Section 329. Now, notwithstanding that, we're going to recommend that you disclose much, much more than that if you're bifurcating Chapter 7 cases, and particularly also if you're using a third party like Fresh Start Funding.
Yeah, and on that point too, so the reason why we're recommending you do these additional disclosures is that the case law out there has talked about these disclosures, and there have been judges who have said they wanted to see more disclosure about this. Mm-hmm. You can be right and say, Your Honor, you're wrong. 329 only requires this. but I think most people would agree a better approach is just disclose everything. We always say disclose, disclose, disclose. Put it all in there so there's no questions. You don't get dragged in front of the judge and have to answer questions. But if you want to be right, you can skip these disclosures and
being right is painful
are.
and expensive sometimes. So we make the point that there is a legal argument that the standard is much lower than what these recommendations are going to require, but then we urge you strongly to actually disclose. And our clients that we work with, we actually insist that they disclose this way as a condition of them having the defense guarantee that we provide, where we'll step in and actually fight the fight if it comes to that.
Yep.
All right, so let's talk now about B2030. And Joni, let's pull up the first slide, which has to do with paragraph 1. And what I'm going to do for these first few is I'm going to show you what the standard form looks like, and then I'm going to show you the changes that we recommend. So what you see here now on this slide is the basic paragraph 1 of the Form B2030. And you see there the fill in the blank lines say, for legal services, I have agreed to accept. Prior to the filing of this statement, I have received, and then balance due. It's interesting, this language agreed to accept. There has been some attempt to make something out of that in the world of financing, the idea being that if you are paying a fee to a financing company, all you're ultimately getting is sort of the net fee, if you will, after paying the financing expenses. And so you have agreed to accept something less than the full fee. We'll talk about how that's conflating two completely different ideas here in a second. But what I want to start out with is just pointing out that that language, have agreed to accept, has no basis in the code or rules. It doesn't appear anywhere. If you look back at section 329, which we had a prior slide on, what it talks about is what the debtors agreed to pay, not what you've agreed to accept. And so we're going to make a change in our recommendation, and let's slide over to the next image there. We're going to suggest that you change the language there to debtors have agreed to pay, because that is the language that's directly out of 329. And as we pointed out, Rule 2016 doesn't require anything other than the statement that is required by Rule 329. The other things here are probably pretty apparent, and that is that you want to list the entire fee that the debtors agreed to pay. If it's a true zero down case, you're going to list 0 on the second blank there, because you will not have received anything for your pre-petition services. And the entire balance is the post-petition fee that you'll list on the bottom line there. Now, if you're going to bifurcate differently and perhaps collect $500, $1,000, whatever it might be up front and do more of the work, then you would need to disclose the fees accordingly.
Another interesting issue we should talk about a little bit right on this form too is that some attorneys include any expenses that they're collecting in that number, and some attorneys don't. And so, it does talk about compensation, so it probably doesn't need to include expenses. However, if your debtor in their mind is paying $2,000, which happens to include the filing fee and maybe other expenses, I like having it be $2,000 here so everything's consistent. But as we'll talk about later, you just want to make sure in your disclosures, you just make it clear that it's $2,000, but it does include the 335 filing fee or anything else that might be included in that. That way it's a complete disclosure and all the documents will be consistent.
Okay, let's move on to paragraph 2 in Form B2030. This is the one that inquires about the source of the compensation paid to you. So this speaks in the past tense. And so in a true zero down case, at the time that you file the Form B2030 disclosure, you will not have been paid anything. And so this doesn't really adequately disclose that. So what we're going to recommend that you do in the next slide is add a box that says not applicable. So as to a true zero down case, you will not have been paid anything. So talking about the source of the compensation as having been the debtor or other is kind of an opposite. You really need a third option, which is not applicable. Now, if you're bifurcating differently and you're collecting something up front, then you would simply check the box that says the debtor, or as applicable, a third party, if it's mom or dad or somebody like that, paid you your pre-petition compensation. Okay, so let's talk about question 3 on Form B2030. And this is the forward-looking disclosure as to the source of compensation. And this one does not change if you're bifurcating and or using third-party financing. As long as you're not factoring. There is a question, I think, intellectually, if you are factoring, literally selling the receivable, whether you're ever getting anything from the debtor because the only source of funds you ever have is from the factor. If you're using a recourse financing source like Fresh Start Funding, we act as your agent to manage the payments, but we're collecting them in your name. And so you literally are still collecting your compensation from the debtor. And so it's appropriate in response to question 3 to check the box that says debtor is the source of compensation to be paid to you in those post-petition installments.
Yep.
Let's take a look at question 4 on Form B2030. And this is where we get to compensation sharing. And we are not suggesting any different form for paragraph 4 if you're using a third-party financing source, so long as it's not a true factor. That's going to be a different mix of issues that you're going to have to sort through ethically and in terms of the disclosure. But as long as you're using a true financing company, it's no different than if you had a line of credit with the bank or you were drawing money off of a credit line or something like that to help operate your practice. And there are ABA ethics opinions and state ethics opinions that highlight the fact that financing, even where you're pledging the receivables, doesn't implicate fee sharing in any way. Because truly, for most of us who operate a law firm, our only source of revenue is attorney fees. So are you sharing fees when you pay your bar dues with those attorney fees? Are you sharing fees when you pay your employees their salary or when you're paying your rent? And I think pretty clearly we'd all agree that the answer is no. And so if you're borrowing off a credit line and repaying that credit line, and someone's managing your payments from the debtors, you're not fee sharing. So here, I think you are safe in checking the first box, which is that you've not agreed to share your compensation with anyone else.
Yeah, and this is another point, another part where I would say if you really want to do a deep dive on this, we do have a lot of information on this, and we have briefing we've done, so we'd be happy to share it with anybody.
Absolutely. Okay, so let's stop the screen share here for a second and talk about questions 5 and 6. So question 5 and 6 accomplish 2 things. Question 5 has a stock description of the services that you've agreed to provide the debtor. And I think in almost every instance, using the stock description is probably fine. If you have a local limited scope representation rule, or what we commonly call RARAs or notices of rights and responsibilities, you probably do want to take a look at those lists of services and make sure that your disclosure is at least not inconsistent with them, if not beef it up to be completely consistent.
And that is something where I'll say, I mean, when I look at Form B2030s that people file across the country, if they're not working with us, they almost always just use the standard stock language, and it's often wrong. And I'm sure the people on this webinar would not do that, but you need to make sure that you are describing and not your services that you're providing, and not just relying on the stock language in there.
Yeah, correct. And then question 6 has to do with disclosing any exceptions, any services that the debtor and you have agreed you will not provide. Typically, under local rules, you have the ability to accept adversary proceedings. And then there's a wide variety across the country about whether you're obligated to deal with reaffirmations, redemptions, other contested matters, and you have to look at your local rules to make sure that you're complying with those. But that question 6 is where you would disclose anything that you and the debtor have agreed will not be part of your flat fee engagement in the Chapter 7, either under your pre or post-petition services agreement.
Yeah, and one thing I guess on that issue though too is that sometimes attorneys and U.S. trustees will conflate the issue of the services provided and whether or not you're being paid for them. So even in jurisdictions where maybe you have to continue into an adversary if it comes out of the case, I've never seen a local rule that also says you cannot get paid more for that. So you can make it clear that you're providing the service, but that there would be additional fees that you'll be collecting on that.
What's interesting in the bifurcation world too is that a lot of times those things are not known at the time that you enter into your engagement agreement. And there is case law out there that slapped attorneys for taking pre-petition money for things that came up post-petition, like non-dischargeability actions and things like that, which seems to corroborate really strongly the idea of bifurcation, in that you're being paid post-petition from non-estate assets for post-petition services. Okay, so here's the point where we're not going to be talking so much about what the basic form provides, and we're going to talk a little bit more about additions to the form. So the first thing that we recommend that you do, and Matt alluded to this earlier, is deal with the question of the filing fee or other costs. And we recommend that you add a new paragraph 7 to your Form B2030 disclosure if you are going to wrap the filing fee into your flat fee that's disclosed in paragraph 1. And so we've got a note here that it's if applicable, because if you are collecting the filing fee pre-petition from the debtor, or the filing fee is an add up to your flat attorney's fee, this disclosure will change somewhat. But I think this is a point that even outside the world of bifurcation, as Matt said, attorneys often get wrong, because really paragraph 1 is supposed to be dealing with compensation. Okay, moving on. We also recommend that you add a new paragraph 8 to Form B2030, and this is a disclosure that is going to describe the options that the debtor was provided for how they would structure their engagement. So what we recommend here is something along the lines of, debtor has been offered 2 options for the payment of our fees, either to prepay them in full prior to the case being filed, or to bifurcate your services into pre and post-petition work in order to facilitate the debtor getting the case filed right away and making payments post-petition. And certainly if you charge a higher fee, this would be a good place where you might even want to add details about, the prepaid fee was X and the pay over time option was Y. Again, I think this exceeds the minimum requirement of disclosure, but there really is no downside to disclosing more than you're required to.
Yeah, and part of this disclosure's design is to also deal with the best interest issue, whether or not it was in your best interest of your client that you bifurcate the case, charge a higher fee, and collect fees post-petition. If you're making it clear to the court that your client had 2 choices and they made the choice, then it is in their best interest.
Yeah. Okay, so the next one is similar, and it's an additional paragraph 9 that we recommend that has to do with describing the structure of a bifurcated agreement. So if you've got the client that chooses the pay over time option, you're going to want to add some color in your disclosure about how you structured things. And so this is a little bit dense, but essentially what it says is that we've entered into 2 separate fee agreements for pre and post petition work. Here's a description of the pre-petition fee agreement, describes the minimum services that are provided pursuant to that. Obviously, you would want to tailor this to your practice. So if you're not offering a zero down case and pushing a lot of the work to the post-petition environment, you'd want this to match what you actually do. And then the second post-petition fee agreement was signed after the petition was filed, relating to post-petition work, and that's where you'd also color up the description of the work there. And then there's a reference back, as you can see, to section 1 of the Form B2030 that references the balance due as being, in fact, the post-petition agreement that's tied to the post-petition services agreement. There's also a final sentence of this that would apply if you are giving them terms for payment of that post-petition fee that would say, essentially how long you're allowing them to pay. Okay, so moving on to what we would recommend is paragraph 10 on B2030. This has to do solely with the idea of using a third-party company like Fresh Start Funding to obtain financing and to manage payments for you. And this is, in fact, the one that we recommend that our clients use. So it's specific to us, but you could tailor this for use with other relationships as well.
And again, it goes way beyond section 329,
yeah,
but we still highly recommend and actually require for our clients.
Yeah, so what we do here is we describe the relationship, so there's no question that it's not factoring, it's actually recourse financing. It discloses the fact that there's going to be a lien taken in the receivable from this debtor as well as your other fee receivables. And that we're going to be acting as your agent to manage the payments and applying those payments against your indebtedness. It describes the services that we provide. It describes the fee that we charge, which is something that's come up more recently in the case law, that courts like knowing how much the fee is to Fresh Start Funding, even though, as we said, reasonability of fees has to do with the lodestar analysis of the fee you actually charge. There is still this attention that's given to what they see as an upcharge to try and recoup the financing cost. As it happens, there is an ABA model ethics opinion, number 484, that talks about the fact that you actually can pass on financing charges to clients. So even if you looked at it from that perspective, the idea that you're charging more to the client because it's going to cost you that much more to offer the post-petition payments is not in and of itself wrong. It's certainly not prohibited under the bankruptcy code, and it's not prohibited by the rules of professional conduct either. But this is a good stock description, and you'll be able to access this in the forums after the webinar to kind of dive in a little bit more deeply.
Yep, I have one more disclosure.
Yeah, so we've got one more paragraph, and I'm sorry, the title on that's wrong. It should be 11, not paragraph 1. And this is, in a way, kind of completely gratuitous. I will just go out on a limb and say that. It's way beyond anything you need to do under Section 329. But I still think it's a good idea to note that you fully inform the debtor about how the bifurcation works, about your relationship with Fresh Start Funding or any third party that's providing financing or payment management, including the limited information sharing and so forth that's going to be required to facilitate the payment management services.
Yeah, because if nothing else, it helps prevent the judge calling a status hearing to ask you these questions.
Yeah.
So,
and we have seen that happen, by the way. I've staffed a couple of status hearings where the judges were just curious. They hadn't seen the practice before. And once we were able to point them to these very robust disclosures in Form B2030 and walk them through it, it actually answered all of their questions, and really nothing went on beyond that. So, all right, so we've reached the end of the plan presentation. I think we probably have a little bit more in the way of Q&A that we will deal with. But before we get into that, I just want to remind you at the end of the webinar, a slide will come up that'll give you a link that you can follow that will give you access to a lot of our forms and disclosures and so forth. And we're also available to talk to you at any point in time that you'd like to. We're big old nerds on this topic. So we love talking about these issues and helping steer attorneys in the right direction to avoid the mistakes that have gotten some attorneys into trouble in the past. Eugene looks like he's typed the start of a question, but it doesn't look like it's
reading
finished.
it, I'm like, am I misreading this? But yeah, it looks like it didn't quite get in.
Yeah, so I'm not sure where that one's going. Jeff is asking, is there any update of the recent Minnesota case on bifurcation? No, there's not yet. It's fully briefed at this point. We had a status hearing on it last week. There's going to be a limited period of time to allow for some discovery, and we're looking at probably the middle of May for an evidentiary hearing. And the issues there primarily have to do with the judge looking at reasonability of fees. The disclosure issue's been already vetted in a prior hearing. So we are eager to see what happens there, and I'm pretty optimistic that we're going to see another positive decision on the heels of the Carr case coming out of the Eastern District of Kentucky, where like Hazlitt, the process and the disclosures and the fees and everything were vetted completely, and the judge gave a seal of approval to the structure of the engagement. So we do see a developing inertia and body of case law coming out of this that continues to refine the standards for best practices, but is clearly supporting the idea of bifurcation and offering post-petition payment terms.
Yeah, because really this past year with, in 2019, when Clifford White, the head U.S. trustee, came out and commended the analysis and Hazlitt, it really has changed the discussions with the U.S. trustees. It's no longer questions about whether or not you can bifurcate. It's just questions about fees and disclosures.
Yeah, correct. So Jack is asking, do you require we charge a minimal amount for our fees? We do. In terms of the financing, we have a range of contract values that we finance. It's between $1,000 and $3,000. And I can tell you we have made exceptions both below and above that amount, as different markets have demanded that. So we have some rural areas where the fees are quite low, and we have some very expensive metropolitan areas in Southern California and New York where the fees are higher than $3,000.
And then
we've got so one question, John has some questions about what our program provides. And I will tell you, we don't have a lot of time and didn't intend for this to be so much a commercial about Fresh Start Funding as really kind of a thorough discussion of technical issues and so forth. But we have a very friendly payment management process.
Yeah, but we're proud of our collection
process,
so we're going to talk about it.
We're happy to talk about it. So, we are not anything close to what you'd call a collection company or collection agency. We have a relationship-based payment management service where we conduct a welcome call with the debtor as soon as you send the contract to us for management. We're always collecting or managing the account in your name. And the messaging is always very consistently about a fresh start and about trying to keep them on track so they get the benefit of the positive credit reporting that we offer, because they can literally start increasing their FICO score by making your attorney fee payments to us because of the relationship that we have with the credit reporting agencies. So it's all a very friendly process. And candidly, we don't ever send anybody to any more aggressive collection. We don't sue. I mean, we have mechanics built into the finance agreement that if the bottom fell out of everything, if you disappeared and we had to collect. We have the right to pursue that, but we would never do it until after you finished the engagement, and if there's no other way for us to collect the payment. And it's just very friendly and very effective.
Yep, for sure. And we've invested, a lot of money and a lot of time into our process, into our people, and the technology. So it's very robust. It's cutting edge, and it works really well.
So Robert's asking about an update on Hazlitt, and there's really nothing more to say about Hazlitt. There was a continuing fight in the Hazlitt case. And there's a long backstory about Hazlitt. There was a disgruntled attorney who wasn't hired, who offered only a flat fee, who kind of took up the battle with the attorney who the debtor did hire, who offered post-petition payments. The bifurcation issues have all been fully resolved with the Hazlitt decision in April of 2019. And there has been some continuing litigation in that case on unrelated issues, but that order of Judge Anderson has not been appealed. And even though it's not controlling authority, obviously, for anybody, it is a topic of national conversation, and it is being cited as persuasive authority in every case where bifurcation is being raised. And as Matt mentioned, Cliff White, who runs the U.S. Trustee Program out of D.C., was speaking to the National Association of Bankruptcy Trustees in August at their annual meeting of last year, and actually commended the Hazlitt decision as illustrating the factors that the U.S. trustee looks for when they decide to come in and ask questions in a bifurcated case, and said that it was a well-reasoned analysis and commended it to not only the U.S. trustee program, but the bar. And I'm dealing with U.S. trustees, staff attorneys, and assistant U.S. trustees across the country on a regular basis. And I can tell you that they have essentially adopted the Hazlitt approach, which is to say, they're not asking whether or not you can bifurcate anymore. They're simply looking into adequacy of disclosure to the client and best interest, adequacy of disclosure to the court, and reasonability of fees. And those are the topics that will continue to be questioned and discussed for a bit of time yet as standards continue to be settled.
And we have one other kind of nuts and bolts question that Clay's asked, and that's whether or not you would disclose on Schedule I the payment that the debtor makes post-petition. And so the answer to that is yes, with maybe an asterisk. Schedule I is supposed to be disclosing payment obligations that exist immediately after a petition is filed. So for example, if they file bankruptcy and then go get a car loan the next day, that car payment technically shouldn't be on Schedule I. However, in talking with trustees, they have said that they want to see the post-petition payment on Schedule I. So the best practice we promote to all of our attorneys is do put that payment on Schedule I. In fact, if ever a U.S. trustee were to have a problem with it, which hasn't happened, it's better to take a payment off than to have failed to disclose a payment.
I think it's J, isn't it? I's income and J's expenses.
I'm saying
J.
I.
Yeah, it's actually Schedule J. And Schedule J does have in the instructions the idea that if a payment, an obligation is contemplated at the time of bankruptcy, that you should probably list it. But regardless, look, it's better, again, disclose. Put the payment on there. People can't really question you for putting it on there versus leaving it off.
And so I guess my defense is I don't have my readers, and I think I misread Clay's questions. He actually is asking about whether or not you'd show the income on Schedule I, and I thought he was talking about the expenses of Schedule J. And I'm not sure I fully understand the question either, but you would just still do your means test in the normal manner and Schedule I in the normal manner.
I think where this is going is some trustees have argued under the best interest analysis that if someone's upside down in their budget, that they've got a deficit in Schedule I because their budget in Schedule J is so high that they can't possibly have the money to pay you your attorney's fees. And the way we approach that in litigating these issues and trying to educate parties is to point out that they're in that same budgetary deficit before the petition is filed, and usually in a worse position because they're being chased by creditors to pay what will otherwise be dischargeable debts. And under the traditional system, you're expecting them at that point of highest financial distress to come up with the entire fee to pay you to file a Chapter 7. And so we typically have debtors acknowledge in the paperwork that even if their budget analysis, their means test, or the Schedule I and J balance shows that there's a budgetary deficit, that they still believe that they're able to make the payment and that it's a better solution for them than if they were to have to try and pay the fee pre-petition. And thus far, that seems to have resonated with the folks that we've talked to about that.
And there seems to be a different approach to I and J in different states. In some states, There's not, when a Chapter 7 gets filed, they can be very negative and there's no questions raised at it. We've heard from attorneys in other jurisdictions where U.S. trustee wants the budget to be balanced. They want to know that after they file bankruptcy that they do have a budget where they can move forward on. So they adjust everything to try to make it as break even as possible.
So John, we've got another question. John asks, have you seen any limitations on filing cases under this model versus being prepaid where there's little or no reason to file the case immediately or quickly? So really what this is getting to is this something that you can only use if there's an imminent garnishment or an imminent repossession of a car or something like that? And there's no legal reason for there to be a distinction between those things. It's either legitimate under the code or not. And for those of you who are kind of bankruptcy nerds like me, you'll know that the doctrine of necessity, which is where courts have sometimes fashioned remedies that really weren't allowed under the code, has been frowned on for a number of years now. The Fifth Circuit in particular really took a hard line against, judges modifying the code essentially to meet the exigent circumstances of a case. The simple fact is that we believe that this process is consistent with the code, consistent with the rules, consistent with your rules of professional responsibility. So the way I try to put this, practically speaking, is even if there's not a garnishment or something like that, where this process, I think, makes sense to a lot of people. And let's just say somebody could potentially come up with your prepaid fee to pay you. Is it in their best interest to do that up front, or instead to use that money to get some health care for their kids, or to prepay a month's of their rent, or to go to Costco and actually put some food in their pantry before they file the bankruptcy case? And I don't know, it's an interesting discussion, but to put it simply, we don't believe that there is or needs to be any distinction. And we haven't seen any case law on this topic either.
Yeah, if I could add a little color to that, I mean, we've certainly heard from some attorneys who've had their local trustee tell them, yeah, you shouldn't do it unless there is some emergency like a garnishment. But it's never been argued in the cases anywhere. And the reason is that there's nothing legally that supports that position. I mean, as Dan says, the code's super clear what it requires to start a case. It's very clear on who qualifies to file a Chapter 7. There is nothing out there that talks at all about when you can or cannot do a skeleton, or when you can or cannot, kind of do a quick filing.
All right, it looks like we've got one more question, then we need to wrap things up. We've kept you longer than an hour here, but Sharon asks, would you list the FSF payment on line 16 of the Statement of Financial Affairs or leave it blank? Question 16 on the SOFA actually is a backward-looking question. It asks for payments made to an attorney in contemplation of bankruptcy. And so if you charge something for your pre-petition services, yes, that portion of your fee would be listed in response to question 16. But if you're doing a zero down, or if you're just talking about the post-petition portion of your fees, that would not be listed on question 16.
Yep.
Okay, so we're going to wrap things up. As I said, you're going to have a slide here at the end of the presentation that's got a link for you to get access to our forms. There's also a toll-free number for you to call to get in touch with us. And as I said earlier, Matt and I are very happy to talk to you anytime about the questions that you may still have after this presentation. But do take a look at the information on our website. We've got quite a library of research and articles and forums and things like that for you to take a look at.
Yeah, and on the legal analysis, we have very, very deep dives on all of that. So we're happy to share it.
Absolutely. Thanks for spending some time with us this afternoon. We hope that this has been helpful to you, and we really look forward to hopefully talking to many of you about how this is something that could help you to help more people in your practice and to do well in the process. Our mission is to make the Fresh Start affordable and accessible to everyone, and I look forward to talking to you more about that.
Thank you.